Greetings and welcome to Courts This Week on LiveLaw. I am Taniya Pandey, and every week I bring to you the latest updates from courts across India. If you're here for the first time, I'd say you subscribe to LiveLaw so you don't miss any legal updates. In today's episode, we'll cover judgments that were delivered in the last week of January. Let's begin the episode with judgments from the Supreme Court. The Supreme Court has observed that the right provided to the victim to prefer an appeal against the order of acquittal is an absolute right and there is no necessity to obtain a special leave. The victim has a statutory right of appeal under proviso to Section 372 CRPC, and the proviso does not stipulate any condition of obtaining special leave to appeal like subsection 4 of Section 378 CRPC. The bench of Justices M.R. Shah and Sanjeev Khanna observed in a judgment delivered on 25th January. The Supreme Court on 28th January delivered its judgment on the issue relating to reservation and promotions for scheduled castes and scheduled tribes. Centre and states had urged the Supreme Court to settle the confusion regarding the norms for reservation in promotions, saying that several appointments have been stalled due to ambiguities. A bench of Justices L. Nageshwar Rao, Sanjeev Khanna and B.R. Gavai had reserved the judgment on October 26, 2021. The court held that it cannot lay down any yardstick to determine inadequacy of representation, that the state is obligated to collect quantifiable data regarding adequacy of representation, that cadre should be a unit for collection of quantifiable data for reservation, that the Nagaraj judgment of 2006 would have a prospective effect, and that the conclusion in B.K. Pavitra 2 approving the collection of data on the basis of groups and not cadres is contrary to the dictum in Jarnail Singh. The Supreme Court on 28th January stayed the publication of the winding up order passed by the Madras High Court against airline company SpiceJet Limited. However, a bench of CJI N.V. Ramana, Justice A.S. Bopanna and Justice Hima Kohli also made certain critical remarks against SpiceJet. Senior Advocate Harish Salve, appearing for SpiceJet, sought for 3 weeks' time, saying that they are working things out with the creditor, Credit Suisse AG, a Switzerland-based stock corporation, on whose petition the High Court had passed the order. The matter has been adjourned for 3 weeks and publication order stayed until then. The Supreme Court bench of Justices Ajay Rastogi and Abhay S. Oka has held that the High Court of Delhi, having original civil jurisdiction, can entertain a petition for executing a money decree in excess of Rs 20 lakhs of a foreign court, which is notified as the Superior Court of Reciprocating Territory under Section 44 Capital A of the Code of Civil Procedure. In this case, an appeal was filed assailing the order of the Division Bench of the Delhi High Court, which had held that High Courts have no jurisdiction to execute foreign decrees under Section 44A, even when it falls within the pecuniary jurisdiction of the High Court, as Section 44A is an independent provision distinct from execution of domestic decrees. The top court allowed the appeal. The Supreme Court has observed that a High Court, while exercising revisional jurisdiction under Section 401 CRPC, cannot convert a finding of acquittal into one of conviction. The bench of Justices M.R. Shah and Sanjeev Khanna observed that if the order of acquittal has been passed by the trial court, the High Court may remit the matter to the trial court and even direct retrial. However, if the order of acquittal is passed by the first appellate court, in that case the High Court has two options available. First, to remit the matter to the first appellate court to rehear the appeal, or two, in an appropriate case, remit the matter to the trial court for retrial. The Supreme Court bench of Chief Justice of India N.V. Ramana, Justice A.S. Bopanna and Justice Hima Kohli on 25th January issued notice to the Union of India and Election Commission of India in a plea seeking directions to the ECI to not permit political parties to promise or distribute irrational freebies from the public fund before elections and deregister political parties or seize election symbol of the parties which do so. The petitioner has argued that arbitrary promises of irrational freebies violate the ECI's mandate for free and fair elections and distributing private goods and services which are not for public purposes from public funds clearly violates Articles 162, 266(3) and 282 of the Constitution. It is now time to take a look at the important judgments from the High Courts and other courts. A convicted prisoner who has been in solitary confinement for 2 years and 4 months had written to the Superintendent of Central Prison, Aurangabad, in anguish, but his request fell on deaf ears. The Bombay High Court's Aurangabad bench took cognizance of the petitioner's wife's letter and directed prison officials to transfer him to an ordinary prison cell with immediate effect, and ordered a team of doctors to visit the prison and ascertain his condition. The bench of Justices V.K. Jadhav and S.C. More further directed the Chief Judicial Magistrate Aurangabad to visit him in prison, record his statement and report to the High Court on the condition of the under cell. The bench observed that Section 46, subsection 10 of the Prisoners Act does not permit cellular confinement exceeding the period of 14 days. The Delhi High Court has continued hearing a batch of petitions challenging the exception to Section 375 of the Indian Penal Code, which exempts forceful sexual intercourse by a man with his wife from the offence of rape. Advocate R.K. Kapoor, representing NGO Hriday, opposed the criminalization of marital rape and submitted before a bench of Justices Rajiv Shabdar and C. Harishankar that forceful sexual intercourse between a husband and his wife in a marital relationship cannot be labelled as rape and at worst can only be called a sexual abuse. Senior Advocate Rebecca John, appearing as amicus curiae in the matter, submitted that availability of other provisions including Sections 498A, 304B of IPC, Domestic Violence Act and other civil remedies are insufficient to deal with the offence of rape under Section 375 as regards to a wife alleging rape by her husband. Stressing that law acknowledges a woman's right to have sexual relationships, the Punjab and Haryana High Court has recently observed that consent given during prior sexual acts won't extend to future occasions. The bench of Justice Vivek Puri further remarked that withdrawal of consent effectively nullifies the earlier consent and therefore forced sexual intercourse becomes non-consensual, attracting the penal provisions of Section 376 IPC. The Andhra Pradesh High Court has ruled that Section 52 of the Transfer of Property Act 1882 does not operate as a bar to grant of temporary injunction under Order 39, Rules 1 and 2 of the Civil Procedure Code. Justices R.N. Tilhari and C. Praveen Kumar, in a common judgment, observed that Section 52 of the Act does not come in the way of passing an order of temporary injunction restraining alienation of the suit property during the pendency of the suit on the application satisfying all the three ingredients of prima facie, balance of convenience, and causing irreparable loss or injury in his favour. The Allahabad High Court has stayed the decision of the Uttar Pradesh government to appoint 6,800 additional candidates as primary assistant teachers in the state, in addition to already appointed 69,000 candidates. The bench of Justice Ranjan Roy made it clear that the government cannot appoint more than 69,000 candidates without issuing an advertisement regarding the same, since in the original advertisement issued by the state, only 69,000 posts were intended to be filled. The National Company Law Appellate Tribunal, in a bench comprising of judicial member Justice M. Venugopal and technical members Mr. B.P. Singh and Dr. Ashok Kumar Mishra, has held that there exists a difference between supersession of directors under the RBI Act and suspension of directors under the IBC, and that a superseded director who vacated office on supersession of board under the RBI Act is not entitled to the notice of COC meeting and has no right to participate in the meeting. With this, we've come to the end of today's episode. Subscribe to LiveLaw and click the bell icon to not miss a single legal update. I am Taniya Pandey and you're watching Courts This Week. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.